Hi, I'm Carl Pearson, and the evil that I want to cure is the sale of defaulted promissory notes of all types, often for pennies on the dollar, followed by collection lawsuits for many dollars more than the face amount of the defaulted note. You have to keep in mind while you look at this video the difference between secured notes, such as with home mortgages, and unsecured obligations, which really are the same as a note, such as with credit card obligations, which I'll call notes. I won't cover the abuses I've seen in credit card lawsuits. It would take one or two videos to discuss. Now, let's say you owe $10,000 on a credit card and go into default, and the credit card company has given up after numerous attempts trying to get you to pay, and sells the note, that is your obligation, with 50,000 others to a company in the business of collecting on defaulted notes for its own account. It probably paid about, the company that bought the note probably paid about $300 to $500, or 3 to 5% of the $10,000, and brings suit against the debtor for the $10,000 principal amount owed, plus interest, default interest, late fee charges, legal fees, and probably other charges that they throw in, so that the amount they claim the credit card debtor owes the new purchaser becomes $13,000, let's say. Now, there is a multi-billion-dollar industry that's recently developed buying up defaulted mortgage notes for the primary purpose of collecting them by foreclosure and sale and eviction as to notes secured by homes. This new industry followed the long-established and highly abusive industry of buying defaulted credit card notes to sue and obtain a judgment for enforcement by attaching bank accounts, savings accounts, cars, wages, as to credit card notes and other secured obligations. The Goldman Sachs Group, Inc. is a publicly held multinational investment bank and financial services company headquartered in New York City. Goldman Sachs, through its wholly owned subsidiary MTGLQ Investors LP, and MTGLQ obviously means mortgage liquidation, has purchased more than $7 billion in defaulted residential mortgage notes, and admittedly has sought foreclosure and sale for most of them. Other funds are being assembled, often referred to as vulture funds, as an easy way to get a 100% return on the investment in 6 months to a year. Mortgages generally give banks a 4% annual return, but vulture funds go for 25 to 50 times as much at your expense. This nation is in a deflationary economy favoring the creditor and severely hurting the debtor, who is required by law to pay back debts incurred when the economy kept heading upwards, with substantially lower income or even no income and an inability presently to afford food for the family. The debtor has serious problems. Bankruptcy is a way to take care of the credit card debt, but doesn't necessarily get rid of the home mortgage. I have a solution for this problem as to unsecured debt, which is to devalue the purchased defaulted note to the amount for which it was sold, and if this can't be determined, then to say 4% of the principal amount claimed to be owed, or the lesser of the two amounts, with interest of say 3% thereafter. The $10,000 credit card debt in default upon sale would automatically be reduced to $400 or less, plus 3% interest, something hardly worth suing for and far more manageable for the debtor to handle. and enabling the debtor to avoid bankruptcy with all of the attendant costs and problems. This proposal of mine would require the payee seller, in this case a credit card company, to not sell the note and instead take a write-off of the debt. This write-off would give the debtor taxable income on an IRS Form 1099 miscellaneous to the extent of the write-off, which the debtor would either explain in his or her tax return was a contested debt, or seek relief from the IRS through a settlement procedure known as an offer in compromise. My proposal, if enacted into law, would tend to eliminate sales of little value defaulted unsecured notes to vulture funds that hope to score big when collecting 20 or 30 times the amount of their investment from too many of the note obligors who are in financial trouble, probably not their fault. The rich have idle cash to put to work creating further misery for the 99%, and this one area where we could prevent the practice by simply devaluing the already devalued notes to its approximate present value. I see a lawsuit challenging the devaluation as an unconstitutional impairment of contractual rights, but the circumstances of the prior effort to collect and the devaluation and sale and state of the economy probably would survive any such attack. As to the secured obligations or notes, at a minimum, the defaulted note should be reduced to the appraised value of the property securing the mortgage, with a reduction of interest to 2%. It might require a federal statute setting up a fast in and out trip to the bankruptcy court to accomplish this. All the homeowner would have to do is fill out a form, pay a small filing fee, attach an appraisal from a court-approved appraiser, and have the court automatically devalue the mortgage note and at the same time sign an order removing you from bankruptcy. The owner of the note would be able to retroactively challenge the bankruptcy, challenge the validity of this arrangement, and once it is approved or disapproved, that is, the concept is approved or disapproved by the Circuit Court of Appeals or the Supreme Court, will know whether this idea works. We need to readjust debt to the new economy, and a defaulted note seems the best place to start this needed devaluation process. Well, I've said what I wanted to say, and I'll be back soon with my next video.